name is Maxine.
Yes.
I have instruction to do for the landlord. He's an interested party, and that was living.
By the site, so that the eye can file returns investigations.
It's not a matter that has been filed with a charge sheet. Therefore, the role of the family should be limited because they do not have even a right of audience. In a miscellaneous application, the Victim Protection Act does not come in play because we have not even identified who the victim is. The reason why I'm stating this is I foresee a situation where my senior here will take the opportunity to raise issues that could be prejudicial to my clients. Therefore, in pursuant to that request, I would like the court to either give directions on the role the council would be playing in this miscellaneous application that is only in relation to my client's rights.
I don't want to forget to tell us. What we want us to do is, because the application we made 4 years of time,
If there are any, have to be dealt by the investigations.
Yes.
Yes. Your Honor, may it please the court continue occupying the court's time. However, we remain cognizant of the fact that the matter is still live, if I understood my colleagues correctly, in terms of the broader investigation rather than the miscellaneous file that's before Your Honor. So I would ask for 2 things. And we'll extend the same cooperation to the DPP as needed, with or without this file. And in the circumstances, I would seek that a direction go on record that should the DPP or the IO require the presence of my client for whatever reason, they should summon her through counsel on record, and she shall be available. But that notwithstanding, since bail cannot be held on any non-existence or closed file, I would secondly apply for release closed file. I think the prosecutor should not have any objection to that if they're closing this file. That's all, Your Honor, for now.
East to the suspect. My issue is, in the Victims Protection Act, a victim is defined as someone who is who has suffered from an offense that's been committed.
We have not done what we are saying. You see, I would expect you to respond after he has represented himself and made whatever kind of submission. I don't know what submission is made.
So you know what happened last time is the
The objection is
premature. It's to the right of audience. We want to limit the audience to.
no, I think it's not fair. If there is anybody who wants to make a point and if directly may be affected, I don't see any
Most obliged.
Thank you very much, Your Honor.
let him make submissions. If he makes submissions, which maybe
Thank you very much, Your Honor, for stating the obvious law, which anybody knows that the right of audience, either through a victim or an amicus or an office of the court, can address the court on any matter, and that is the right that I'm exercising. Your Honor, one, the state by the police came before you.
so you are asking to do, can you be specific on the victim?
Very well.
Then nothing is on there.
That's why I was saying the application was to investigate.
So before you proceed, I want you to be very specific on
The family of the
I'm appearing for the family of the killed person, Ashad. The murdered person. Because the murdered person cannot give instructions. I'm appearing for his brothers, for his father, for his relatives. Specific. And that's, Your Honor, the instructions I was trying to tell counsel here that in the miscellaneous application, a dead man has been identified. His relatives automatically become victims. So the application was made to investigate the circumstances of his death. Terminologies have been changed to put the respondent as a victim. The respondent is breathing alive and not dead. The people who have more right to be heard are those who have cremated their own. And I'm representing that voice. Your Honor, number two, a miscellaneous application which is an investigative tool by the police, has three limbs. One, to allow the police or the DCI to conduct investigations in a manner that they will want. That was granted. Two, to preserve the subject matter. Who is the respondent in this matter? That in the event the DPP decides to exercise Article 157 and charge her, she's within the jurisdiction of this court. Conditions as bail, conditions as deposit of passports, conditions of reporting to the police are the constitutional instruments granted to the court to ensure that the respondent cannot move out of jurisdiction. You know, you are being told now, close this file. The investigating officer has not disclosed the recommendations to the DPP. If the DPP decides to charge and the respondent is out of the country, we shall be in a position of absurdity. And this is the first time in the history of criminal justice system, the state is saying, close the miscellaneous without offering that we are not going to charge. Or close the miscellaneous because here is a charge sheet. That is, by experience, what the family expected. The state is allowing a Sahara-like situation grow. What is the actual position of the respondent? The DPP has confirmed they have received the file. What prejudice does this miscellaneous file occasion that it warrants closure? I've been a matter for KRA for the last 3 years. Still, we are running the miscellaneous application pending the determination of the DPP to decide. So this, Your Honor, is strange. And to me, it is a setup that the court has released this person. It is the court that releases. That is why they came to you, asked for orders to detain or allow to investigation, and they are before you to release her and close the file. I'm alive to the reality that this is not somebody who has been charged. The state could have gone through 87A to close. It's provided by law. It is Section 87A. This that has been made to you, Your Honor, let it be put to you under the National Police Service Act. Which section? Or under the DPP Act, which section? Or under the CPC, which section? Under Article 157, which section of the law will allow closure without a definite certain angle to take? What do I tell the family of the deceased? What do we tell Kenyans who are interested in this matter? On a third angle, the purpose of the miscellaneous application is to keep the DPP within timelines. This file can go to the DPP and stay there for 30 years. The office of the DPP will turn into a parking lot. How will my clients follow? Unless now I'm restricted to move to the private prosecution. If this file is kept alive for the purpose of the DPP, and because the file is there to give the court the update, we are at this stage, we need this time. We have reached this type of investigation, we need this time. That is another reason as to why anybody, Your Honor, who appears before you is your word. She's no longer a person of the DPP. She is before you. You have the judicial authority to supervise. You are being excluded. The judiciary is totally being excluded from a very critical question: the supervision of the DPP and the DCI in this matter on behalf of the victims. Your Honor, it is my submission that you deny the application for closure of this file. We take a mention date for the DPP to come and tell us the decision they have made. And it's straight law that nobody can challenge the DPP, whichever decision they come with. But out of that decision, we'll be able to know whether we'll go for private prosecution or we'll go for murder trial, or we'll know what is happening. And kindly don't allow the family and the whole country to be kept in the darkness. But this file now will be is now in the DPP. We don't know for how long. Lastly, Your Honor, the reason of arrest is now being taken so easy. Why couldn't they do investigation and arrest? Is it today they've realized that they needed to do investigations? The respondent, without us saying that she's guilty or not guilty, we are only saying, for now, this is the person the state brought to the world that they are investigating over the death of a child. Let him learn that this is the court. I attacked him out here. So, Your Honor, what you are saying is that it is them who brought her. It is not the victims who brought her. It is them who suspected her. They have not produced a report to exonerate her. If that report comes here, we'll comply and deal with the consequences. Your Honor, I urge that with your many years of experience as a criminal magistrate, you deny this issue. Let them be given a mentioned date. Let them come and tell us what they have decided. Remember, the Chief Justice said the court shall not be a parking lot for files being brought there and left there. We are urging that let the DPP's office not be a parking lot. We can take a mentioned date next week. We are alive to the reality that all the prosecutors in this country are in Mombasa for a workshop, the African Prosecutors Workshop. We can take if the deciders are in Mombasa, we can take a mentioned date next week. Let them come and tell us. Either charge it or there is no prosecution of the respondent, then we'll deal with that matter. My good associate, Ms. Kiara, had one issue she wanted to also raise so that the court can tender its ruling.
I'm swayed by Article 48 of the Constitution, which grants all parties access to justice. And in light of that, the family, in its quest for justice, for statements that are being relied on in the investigation that will be resulting in the recommendations that the ODPP would make. I'm swayed by Article 48 of the Constitution, which grants parties access to justice. And the family is seeking for justice at this point, in knowledge and in view of the investigations and the recommendation that will be made by the ODPP. And that will be humbly submitting on our application to be granted the statements that have been written by all parties.
The alleged events, the subject of the current miscellaneous application before court, happened. It is the landlord's submission that he is suffering loss of rent income on account of the fact that he is not receiving rent since the events before court started to date. The arrears stand at the sum of Kenya shillings 269,500. And having keenly listened to the able investigating officer, it was his submission that there is no decision yet to be made by the DPP. And in his quest, he made an application seeking for the closure of the miscellaneous file. I didn't get him to indicate whether he is still carrying on any investigations. It is our humble request then that Your Honor directs that the IO yields vacant possession of the premises, which specifically is apartment number 3, Block D, Preston Court, Kileleshwa, to the landlord, so that he does not continue to suffer loss of income. Apartment number 3, Your Honor, Block D, Preston Court, Kileleshwa. Preston Court P, yes. Given the admission by the IO that they have completed investigations, as far as the miscellaneous application before you is concerned, they yield access to the landlord. That is all, Your Honor.
Council can be guided by the relevant law to file an application before court for release of that property to the landlord. It does not form part of the application made by court by the state.
The investigation officer says
We have not
yes, but it is the that is why this file is relevant. It's based on counsel.
Application for the court to grant us orders, specific orders, and those orders are contained in paragraph 8. And there's a danger that if the court opens itself to global issues, although touching on what happened in that house, they will not be subject to this application, and the court will be descending into the arena of investigations itself, which is not a role envisioned by the Constitution, the judiciary descending into the role of investigations. Your Honor, we pray that the court be guided by paragraph 8 of that application that is before you, in which the state specifically prayed that the court grant the orders and for the state to be allowed to investigate the respondent. And once those investigations are complete, as per paragraph 8, Roman 9, the IO indicated he will forward the file upon completion of investigations to the DPP for the use of analysis. That has happened, Your Honor. And that is why we are before you asking the court to close that application. We are not releasing anyone. What the DPP is doing is that this ring of the investigation has been completed. It is not a conclusion of the investigations. The DPP needs to peruse that file. The rights of the victim will be protected, as well as the rights of the respondent. And we will not wish to infringe on anyone's rights at this moment. Your Honor, none of those issues which are enumerated in paragraph 8 have been touched by Maxine as having not been conducted. The IO has said he has concluded investigations. Documents to the council is unheard in law for the reason that the right to information does not include the right of everyone getting an investigation file to peruse before the DPP has made a decision to charge. The Constitution provides for when parties will be handed documents and statements. And it is once we have an accused person in court who will have those documents handed to them to prepare for trial if there is an accused person. Supervise the DPP and other agencies to confirm that they are indeed performing their duties as provided for under the Constitution. If the family will feel that the decision of the DPP is not a correct decision, they can move the High Court. But a decision has not been made yet, Your Honor. And we did not come before you, Your Honor, on an inquest as to how a death occurred. We came before you specifically guided by paragraph 8 of our application. And that is why the court granted the orders it did. It did not depart from that paragraph. It was guided by that paragraph. The IO indicates he has obtained all he has. And he sought under that application. You know, we are just praying that we be allowed to close this application and to allow the DPP time to go over the investigation file and make a decision on what should happen to those investigations. That's all.
With your kind permission, Your Honor.
Mentioned to this court. But let me start by saying, Your Honor, there are clearly two parties that have a very keen interest in the outcome of these investigations. And those two parties are the family of the deceased person, and we do not trivialize matters pertaining to loss of life. But the second person who has a monumental interest in the outcome of these investigations is none other than my client, who is currently bailed in this matter. And that is why she has continued to offer full cooperation with the investigative authorities. Your Honor, my learned friend has talked of my client as if she's a flight risk. She has nothing to flee from. whatsoever. She has not been charged, accused, or in any way put on the spotlight, save for the fact that she's a witness to the circumstances under which the deceased met his death. So would strongly object to use of terms like murder by a senior advocate like Mr. Omari when a matter is under investigation and is pending before the DPP. He used the word murder.
Your Honor, I want to be protected. I have not referred anybody to be the murderer.
No, he used...
I have only put it very clearly that there is somebody dead.
I didn't interrupt him. I showed him the courtesy. He used the word murder, not murderer. There's a difference in the dictionary if he checks.
Okay.
He used the word murder, not murderer. He used the word murder. Murder implies someone caused the death of another. Willfully. Whoever that person is. We are today in court with no such evidence. So I'm using the word murder and I'm objecting to the use of such language. PC Kibei has said he's investigated the matter. The DPP is yet to make a decision. As Mr. Omari himself said, as the prosecutor said, let us wait for that decision to be made. As I told the court, my client is ready to continue availing herself to assist with any requirements of the DPP, any requirements of the IO, any requirements of any court that may become seized of this matter in future, if required. What we object to is preemptive strikes. Preemptive strikes by parties who, yes, we understand are grieving. They are grieving. Your Honor, as is my client. As is my client. She lived in the same property with the deceased. So this is not a one-way street, Your Honor. And let us protect the independence. And that is my final point. The independence of this investigation is critical. I have gagged my client, Your Honor, since December 12th from media inquiries for interviews on this matter. Gagged her from talking to anybody apart from the IO on this matter. Gagged her from responding to social media. In the meantime, what has been happening? We see media interviews casting all sorts of imputations against her. How frustrating must it be for her to have to keep quiet and listen to all these statements and judgments going on about her and not to talk? And why is she not talking? To preserve the independence of the investigation being carried out by the lawful authorities. We don't have their statements. We don't have their reports. And she's the respondent to this miscellaneous application. What will anybody else do with the DPP's statements or his reports until the DPP says, this is the direction I wish to travel? The rest of us must maintain silence and respect for the independence of that investigation. That's all we can do. And patiently. And let me assure my learned friend, nobody has a deeper interest in the speedy conclusion of this matter than my client, so that she can at least walk out and voice her side of the events that took place, whatever direction the DPP takes. But as of now, she's maintaining absolute silence and allowing them to do their job. Whether they do it in a miscellaneous file or they do it in the DPP's office, Your Honor, this investigation is ongoing. It will not stop until they get to the bottom of how the deceased met his death. And we look forward to that being sooner rather than later. But let's not be policed, supervised, threatened, intimidated, or otherwise coerced by any party. Any party, no matter how aggrieved they may feel, they should allow the law and the legal process to take its course. That's all I wish to state.
Your Honor, I would like to add something by my senior here. None such information has been tendered by the state. Thank you. Have faith in the system and in the DPP to make the right decision. With that in mind, and pursuant to the application made by Council Kihara for information pursuant to access for justice, this is our concern. As has been demonstrated, there has been a narrative that has been pushed by the family. And this narrative has not been based on any information. It was based on hearsay, and that is even the subject of the current. If it does impede the rule of law, it is our contention that any information that they are applying for to obtain now prior to the DPP making his final conclusion is not only premature, but is likely to be misused and abused. Lastly, as the court is pronouncing itself on the issues that have been raised, I would still restate on the role of any other party outside the respondent and the applicant in a miscellaneous application to be clearly addressed. Everything that my senior, Mr. Omari, has stated here is so prejudicial and which will be printed in the media and is not based on an iota of evidence.
I don't know.
I would like to
just a minute. I don't know whether he's Mr. Omari as an advocate or as a family advocate. Because the position I'm pushing across is the family that is mourning. It is the family. It's not Omari. Omari, I have nothing personal in this matter. Neither do I have any personal interest in the respondent. All I'm saying, let the voice of the deceased family be heard.
Therefore, we need to use these terminologies very sparingly. We have a respondent here. We have an applicant. We do not have a victim. We have a deceased. And we would like all those issues to be addressed because the information coming out from the court and also from the bench is what is now coming to prejudice the respondent here. That is all.
Issues have come up upon submissions by all the parties, and the court will need time to make a ruling on the same. So you can take a date for ruling. So we can do this on 15th. I think next week the court will not be sitting. We are attending a magistrate's colloquium.
15th of February?
So I propose, the week of 15th, 15th of
Wednesday, 15th February is fine. Your Honor, since it's a ruling date.